Welcome to the Hot Topic lecture series. We're going to offer these talks every Tuesday and Thursday through the first week of August this summer. CLE credit is 1 credit for today's lecture, and please sign the attendance sheet that's in the back of the room for that CLE credit. There are also Hot Topics brochures in the back of the room by the CLE sign-in sheet, so please help yourself to those. And this is a brown bag event, so please don't feel shy about eating your lunch while you listen. After we have the lecture, we'll have a short Q&A session, so you can be thinking about your questions. And we're pleased to welcome Sarah Reiter, Professor Sarah Reiter, who's going to be talking to us today. She's an alum from VLS in the year 2013. Professor Reiter is the faculty director of online learning, and she's an assistant professor of law here at VLS. She returned to VLS in 2016 after working in the ocean conservation field for several years. She was at NOAA's Office of General Counsel, Stanford Center for Ocean Solutions, and the Monterey Bay Aquarium, and her work has spanned research on the ocean's seafloor to its uppermost polar region, and played a role in the negotiation of several environmental agreements. She continues to collaborate with colleagues on ocean conservation initiatives through cross-disciplinary scholarship, which can be found in journals such as Science and Stanford Environmental Law Journal. Prior to working in ocean conservation, Professor Reiter served as a commissioned Air Force officer specializing in meteorology, where she managed an operational floor of scientists responsible for providing weather support to military bases west of the Mississippi. She received her Bachelor of Science from the Naval Academy, a Master's of Science from the College of Charleston, and her JD from VLS. And this is her second year co-teaching our Ocean and Coastal Law in our summer session program, one of our most popular classes. Today she'll be presenting Using Science and the Law to Achieve Coexistence in a Crowded Ocean. Please welcome Sarah Reiter.
Thank you. So I realized when I developed the title of this talk that it is pretty broad, and it may have been helpful to narrow that in a little more as I was thinking exactly what I wanted to talk about. But this has essentially been the theme of my entire career, my entire law and policy career, coming from my background in oceanography and meteorology, has been largely working with scientists to figure out how we can best manage our oceans. And so I chose this picture of the ocean as the cover slide because I imagine that the people in this room, all of my ocean students are filtering in now. They just had a guest lecture by the Deputy Section Chief of NOAA's Office of General Counsel for Fisheries, so they just finished presenting their cases. But I chose this slide, this image of the ocean, because I imagine not everyone in this room is an ocean person, perhaps an environmental person, and as part of your environmental interest, you think about the oceans. But if we're thinking about prioritizing the many challenges that we have with addressing environmental harms to our environment, the ocean is so vast, and sometimes it seems so calm and limitless, and there are no boundaries, that it can be easier to look at addressing issues that are closer to home. And so part of my job as someone that specializes in oceans is to do a better job communicating exactly why the oceans are important. And the reality is that it's not that calm. We have approximately 2/3 of the global ocean is an area beyond national jurisdiction, so that no one nation state owns. It's a true global commons that we're dealing with. And we think about coexisting, existing together or at the same time. We're talking about nation states coexisting with one another in terms of their interactions on the sea. We're talking about the different activities that companies or nations engage in, and we're talking about the interactions between the impacts of those activities. So as a commons problem, as I've been talking to my students this week, largely we think about that in terms of the negative things that humans are putting into the global ocean and the positive things that we're taking out of the ocean. That is the big global issue that we're dealing with 2/3 of the ocean that is beyond national jurisdiction. So this inner space is less explored than outer space. And if you talk to scientists about this, they'll tell you that protecting marine biodiversity is essential if we want to secure a future for humankind. And they're not being over dramatic. It's based on sound science. So no ocean talk would be complete without reference to Dr. Sylvia Earle and her no blue, no green quote. She has a knack for communicating the ocean's importance in terms that we can all understand. And just an example of that is something that started to be studied around the year that I was born. So this is a model that depicts the most dominant types of phytoplankton in the world's oceans. This was published in Science in 2017. You'll see this is all the phytoplankton, but the most dominant is the Prochlorococcus. Is anybody familiar with Prochlorococcus? Maybe Caitlin, right? So Prochlorococcus is this amazing little phytoplankton that takes in a lot of carbon dioxide and gives off a lot of oxygen. And it serves as the foundation for our ocean food webs. So when the scientists communicated this information, they said this is really an invisible pasture that feeds the entire open ocean system. These areas, these ocean gyres that we once believed were the deserts of the sea, have an extreme abundance of Prochlorococcus. And as Dr. Chisholm has been studying this at MIT over the last 30 years, what she started to realize is that if we could replicate the conversion of energy that this phytoplankton is able to achieve, we could possibly reduce our reliance on fossil fuels. So when we're thinking about the ocean and we're thinking about the global commons and we're thinking about the positive things we take from it and the negative things that we put into it, I'm starting to think more about the positive information that we can get from the ocean without harming the ocean. And what are the governance mechanisms that we already have in place to address that issue? So we'll go back 400 years. I'm glad some of my students are here. Some of this is repeated from Monday. When we think about the areas beyond national jurisdiction, we need to go back to the father of modern international law, Hugo Grotius, in the 1600s. He was Dutch, and he came up with the freedom of the seas. And essentially what he said is that the oceans are limitless and could not be possessed, occupied, or enclosed. That the seas must be free and open to navigation so long as there is no harm to anyone else's disadvantage. This was a convenient theory because of the Dutch East India commerce and the trade and navigation and commerce that was going on at the time. And for the next 300 years, the only thing that encroached upon this freedom of the seas was the cannon shot rule. Any of my students want to explain the cannon shot rule? They're just taking bites? Go ahead, Sophie. Right, so for the next 300 years, that was the only way that sovereignty was really encroaching upon this global commons that we have. But then we started to see technological advances and emerging uses. Post-World War II, we realize that we have offshore oil and gas. The United States puts out the Truman Proclamation, which has nothing to do with what was customary international law, and says that we are actually going to take the seabed and the subsoil, and we're going to be able to extract the resources from that, and we have the right to do that. So the United States puts that out. There are other nations, coastal nations, landlocked nations, developing nations that are starting to say these emerging uses are something that maybe we should all have access to. This is something that should belong to all of us. So we start to negotiate the United Nations Convention on the Law of the Sea. 1982. Took many, many years and many iterations before that to negotiate this treaty. A package deal with over 160 parties, 320 articles. It addresses virtually every aspect of ocean sovereignty, jurisdiction, and use, and it represents the best evidence of what international law of the sea is today. So when I went to the Naval Academy, we studied law of the sea from a naval law perspective because it was important to know in terms of jurisdiction and use. And my students will tell you from their exercise on Monday, when they did Unclose by Design, that negotiating and then actually demarcating the maritime boundaries is really challenging. And then it reflects the underlying interests and positions of different nation states, whether they are landlocked, coastal, or developing nations. So these are the students negotiating. They played Kiribati, the United States, Bolivia, and then we had the High Seas Alliance, which was a futuristic NGO, and we had the International Seabed Authority, which is the intergovernmental organization responsible for governing the bottom of the ocean in areas beyond national jurisdiction. And then they prototyped what they came up with, their treaties. And they were very interesting. The provisions they came up with did not have to be accurate to what law of the sea actually addresses. But this is the answer key that I gave them at the end of that exercise. Today, what we're focusing on, again, is the blue circle that we have. Marine areas beyond national jurisdiction. That is beyond 200 miles. Little iffy part at the bottom of the ocean, the extended continental shelf. That's where countries are able to, based on the limits of their exploitability, submit a claim saying that they should have sovereign right over that area and be able to access those resources. The United States, interestingly, is not a party to Law of the Sea. And in 2012, Secretary of State Hillary Rodham Clinton's testimony on that was very persuasive from a national security standpoint, from a business standpoint. Really, there's no logical reason I can think of for the United States not to join. I'd be interested if other people have a compelling reason. But in particular, one of the reasons that it makes sense to join is because that extended continental shelf is open to discussion in terms of who owns it. So we have the high seas and we have the area. We have the water and we have the land. And if I was going to try and describe these two dueling legal regimes to my children, I would say the freedom of the high seas, which is anything beyond 200 miles, that has to do with the water column, is finders keepers. You have open access to navigate, to fish, to lay submarine cables, which we'll talk about in a little bit because that's a little confusing. Reserved for peaceful purposes and no sovereignty. The bottom of the ocean is the common heritage of mankind. Sharing is caring. It took me years of studying this to come up with those two concepts, right? So this idea is that all rights are vested in mankind as a whole, and there's no such thing as sovereignty in the bottom of the ocean beyond the extended continental shelf for non-living resources. And this is in part based on developing nations and landlocked nations and their positions and their interests and having access to something that arguably belongs to all of us. So what can be really challenging is for this, what we would think of as land-based humans, this ocean water column and the bottom of the ocean, no one has sovereignty for both of those, but the way that we actually interact is entirely different, whether you're on the water, you're in the water, or whether you're on the bottom of the ocean. But we can get behind it. We know what the rules are now. It shouldn't be too confusing. If we're at the bottom of the ocean, we're going to share. If we're not at the bottom of the ocean, we're going to say finders keepers, right? So thank you to Professor Spiegel for the reading that she gave her international law course this spring, because I took this from the reading that they had. I thought it was a very good quote. It is comprehensive. The law of the sea is comprehensive in dealing with the whole non-land area of the world. It has a rule for everything. The rule may be permissive, it may be an obligation, it may confer an explicit freedom or leave a residual liberty, but by not specifying some right or duty. But a Flying Dutchman wandering the sea areas of the world, carrying his copy of the convention, would find that the convention would never fail him. And so that's the question I ask my students, and I'm asking myself as I work in this space. Does the convention, does the law of the sea treaty fail us? We have the dueling regimes. They're pretty understandable. A significant amount of the world has signed on to agree to them. Even the countries that haven't signed on to agree to them are abiding by what has become customary international law. So is it possible that it could fail us? And I would argue that it is possible that it's going to fail us, otherwise this talk would be over right now. The Economist did the work for us in 2014, putting together this great diagram of the trouble at sea, international management of the high seas simplified. So the green boxes that you see, boxes and circles, are international institutions generally and international agreements generally that touch on the ocean space that we're talking about. And for my students that had briefly a touch on the international whaling treaty negotiations with Professor Park earlier, as you can see, that's kind of just hanging out there on the side, which is always wonderful when we try and do an organization chart and there's nowhere to put it, so we just put it on the side. And then you have the blue areas, the ocean-only institutions and the ocean-only agreements. So most of my work has been in law school with MARPOL, with the International Maritime Organization based out of London. So that's for shipping and prevention of pollution, dumping from shipping. And then after law school, with the International Seabed Authority under the Law of the Sea Treaty for the minerals that are on the bottom of the ocean. So as you can see here, we have several different institutions and several different agreements that are not necessarily talking to one another about issues that are happening in this global commons. The IMO is based in London, the International Seabed Authority is in Jamaica, operating under the assumption that they're actually coordinating with one another is a faulty assumption because there are no requirements that they necessarily do that. So we have some opportunity to improve the legal regime that we have and the way that all of these agreements and institutions work together. So what I want to do is take you on a little field trip, a project that I worked on which helped me better in practice actually realize why this was really challenging to work with this amazing, truly amazing package deal treaty that we have that governs, 2/3 of the ocean. So we're going to go to the bottom of the ocean in the Clarion Clipperton Zone, which is in the abyssal Pacific, to see about establishing nature preserves. Now, nature preserves, national parks, marine protected areas, the idea has been around for a while, but the idea of actually establishing parks on the bottom of the ocean, some would say, why would you even need a park on the bottom of the ocean? None of us are ever going to go there. Nobody wants to go there. There's nothing down there that's very pretty. I disagree. But we set about, the scientists that I was working with had actually set about before I came into the picture to establish these nature preserves on the bottom of the sea. So this area that we're talking about is, again, in the abyssal Pacific. You also see the mid-Atlantic ridge, and then in the Indian Ocean. Those are the other really mineral-rich deposits in the area. So a lot of the rare earth minerals that we use in cell phones and a lot of the technology that we use on land, there's potential that it could come from these areas and that it could alleviate the stress that we see in the terrestrial environment. So there's a whole conversation there about the cost-benefit analysis in terms of degrading the ocean environment that no one's ever going to go to and doesn't see versus degrading an environment that might be in someone's actual backyard and could have human health impacts. So, that is a conversation worth having. This is considered the final frontier. In the abyssal Pacific, what we have are these polymetallic nodules, and they just look like little hockey pucks. And the chemical composition of the nodules, 4 of the chemicals that we're getting from the nodules, we actually import right now to manufacture cell phones in the United States. Out of, there are several more as well in terms of the minerals that we can be getting. So when my colleagues and I were working on this, we took this cartoon, which is from the 1980s, from the New Yorker, and it's an image of high society women having their afternoon tea, trying to think about what cause they're going to get behind. And you can see they say, I don't know why I don't care about the bottom of the ocean, but I just don't. And so we modified that. I like to modify things. We modified that. We put cell phones in their laps, and that served as our inspiration for the work that we were doing, because the time is now to care about the bottom of the ocean. Companies are and countries are looking at the bottom of the ocean for these resources and considering their extraction. So this is just an example to show you exactly how this works on the bottom of the ocean, specifically in the abyssal Pacific. It's going to be different if you're in the mid-Atlantic ridge dealing with hydrothermal vents, which I'm not as familiar with. But essentially, you have these huge machines, these rovers that go down and suck up the nodules, and then they separate them and send them through a hose up to a ship. I think what's most interesting about this image is that it looks futuristic. And so this is a company that is figuring out how to extract the resources with as minimized as possible environmental harm, if you look on their website. But it's not actually futuristic. This image was taken on a cruise to the Clarion Clipperton Zone in 2004. And that test mining track is 26 years old in 2004. So since the 1980s, we've been at the bottom of the ocean extracting these resources. And when you talk to the scientists about this, as someone that's, in the law and policy realm, or not a scientist, and say, okay, well, how long is this going to last? When do you think it will come back? How important is it? What types of animals live down there? Are they being impacted? The scientists have a lot of uncertainty associated with answering those questions. And so my colleague, Dr. Lisa Wedding, said, we know that mining will be very damaging based on short-term studies. So again, this is looking short-term at how long it's taking for this area to replenish itself. But we don't know what the long-term and the large-scale consequences will be. And I think the large-scale consequences part of her quote is most important from my perspective, because she's a spatial ecologist. So she's thinking about the impacts that this has, not just on this particular site, but the ripple effect that those impacts have on the broader ocean. And not just the bottom of the ocean, but how that is interacting with the water column and the currents that we have and the circulation that we have. So this is particularly concerning to someone that works in ocean conservation, because it can be challenging to communicate to people why it matters to think before we act in terms of extracting resources from the bottom of the ocean. And because we still don't know what's down there and how it interacts with other species and what it does for our environment. The Prochlorococcus is a perfect example of that. Only within the last 30 years have we really understood that and studied it and realized that it may hold the answers for a lot of the environmental challenges that we face. So there are several species that are being discovered on the bottom of the ocean. And MBARI, the Monterey Bay Aquarium Research Institute, which is located out of Moss Landing in California, it's the closest access that the United States has to the bottom of the ocean, deep, deep ocean, is constantly finding new species and recording video at the bottom of the ocean and cataloging that data. So when my science colleague came to me, she said, I want your help thinking about this issue. I was involved in this project a couple of years ago. We had a workshop, and we were told to try and create a network of marine preserves, nature preserves on the seafloor. And they're based on science. So you can see the green bullets are grounded in science. Maintain the sustainable, intact, and healthy marine populations, that makes sense. Account for regional ecologic gradients. I would need her help to fully explain that. but I defer to her expertise, that makes sense, and protect a full range of habitat types. That also makes sense. She said, they need to be feasible given the law. I can totally get on board with that. That's the bullets in white. Provide compatibility with existing legal framework, create buffer zones, and establish straight line boundaries so that this is relatively easy for us to enforce. So I understood that. And she said, and they need to honor existing exploration claims. And that's when I was like, what? Exploration claims are already happening, and she showed me this image from the work that they had done. You can see the straight line boundaries. All of the yellow and orange are either contractor claims or reserved claims. And we know from looking back at this image that those exploration, if you're not actually seeing an image like this, may not seem like that's that big of a deal, like there's any activity actually going on. But essentially, I found it quite disrespectful and insulting to go to a scientist and say, we want your scientific input to inform where we're going to put these marine protected areas, but we're probably going to have to wholesale move them because we've already granted exploration contracts for mining. So it kind of defeats the purpose from a scientist's perspective. And I said, you can't do this. And she said, this is what they said we had to do. So we put out another paper in advance of an International Seabed Authority meeting. So the International Seabed Authority is the international governmental organization that's responsible for managing the minerals that we're extracting from the bottom of the ocean. So remember, we have sharing is caring. ISA is in charge of sharing is caring. So that means when someone, a company or a nation gets a claim for exploration and exploitation, the International Seabed Authority is going to actually take those resources through the enterprise system and then decide how to divide up the benefits from those resources, the financial benefits from those resources, which is in part why the United States, under the Reagan administration, was not interested in signing on to Law of the Sea, because that idea flies in the face of some of our political ideology, right? So the International Seabed Authority has to think about how they're going to exploit the natural resources and also protect the environment. And so in advance of this meeting where they were going to be coming up with mining regulations, we put out a paper in Science, and we said, we ask that you do a few things based on the law of the sea that you have to operate under. We ask that you stop exploration and exploitation. Exploitation hasn't actually started yet, but we knew from the exploration that that was already causing a problem. And we said you should use workshops to develop networks of nature preserves on the bottom of the ocean. This is one of the first times in human history where we have something that may be untouched, where we could actually put protections in place in advance of touching that area. And then please rely on the scientists. That would be helpful. Thank you. And so one of our co-authors is the High Seas Advisor for the IUCN. She was traveling to the International Seabed Authority meetings. She brought our paper. They said, thank you very much. And it was a huge success. No, it actually wasn't a huge success, but what it was recommendations that were grounded in science. They were consistent with international law, and they were feasible given political realities. So most of my work has been based on thinking about how do we use the existing laws we have to accomplish what we need, not thinking about recommendations that would say we need a new law, because it seems more tangible and feasible in terms of the political realities of doing that. So where are we now? Thank you, Anna. If you're watching, Anna is one of my students, Anna Hazlitt, and she's been doing some research for me. She's up in Juneau right now at General Council, Alaska. She's been sending me great pictures of whale watching tours. So she collected the information on where we are in terms of thinking about the bottom of the ocean and the recommendations that we gave to the International Seabed Authority. This headline, bacteria from the ocean floor can beat superbugs and cancer, but habitats are at risk from the hunger for marine minerals. May 20th, so just a couple of weeks ago. So again, this new idea of the information resources that we can get. Maybe not new idea, but really when we think about a global commons, we think about the negative we're putting in, the positive we're taking out. We're not necessarily thinking about the information resources that could help us. And the scientists saying we need these habitats, we need them to be intact so that we can study these species, so that we can understand what's going on. So just last month, the International Seabed Authority, the Legal and Technical Commission, they gathered to develop the environmental standards for a draft mining code. It will create the framework for exploitation, okay, so beyond exploration. Michael Lodge, he's the Secretary General. He promised the regulations will be finalized by 2020. So you have several companies that are ready to go. Global Sea Minerals started conducting tests in the Clarion Clipperton Zone with an environmental impact statement stating there will be no serious harm to the marine environment. Caitlin. Exactly. So all of the students did environmental impact statements using cumulative impacts analysis earlier this week. We can talk about that in a little bit. And then in this article, Michael is quoted as saying, an extremely important part of our mandate is ensuring appropriate environmental assessments and safeguards in the activities it regulates. No seabed mining will take place until such elements have been agreed by all 168 member states. So what's challenging working with scientists and observing this from the outside is this dual mandate that the International Seabed Authority has to protect the environment and exploit the environment at the same time, and questioning whether that's really going to work because our recommendations are not working. We're using the only law that we have to say you have to use precaution, you have to abide by this. Interestingly, I was telling the students, we have colleagues that have worked in the Mid-Atlantic Ridge. They went to the International Seabed Authority. They used the Convention on Biological Diversity to try and make their arguments, and Michael said, we're not governed by that. We don't have to abide by that. That's not binding law. So in some ways, when people argue that international law is ambiguous and has no teeth and is not binding, it at least helps to use the international treaties, right, that the International Seabed Authority falls under. But even that is falling short of actually protecting this environment and the information that we can gather from this environment. So as of this month, the International Seabed Authority has issued 29 contracts for the exploration of deep sea mineral deposits. So what we know from doing this work in terms of thinking about these marine protected areas is that you have the bottom of the ocean where we're trying to put a marine protected area, that we don't know what the long-term impacts are going to be, and is the sharing is caring approach. And then we have submarine cables that could potentially run right through that protected area that you're going to establish, or it could run right through an exploration or exploitation contract. And that's using freedom of the seas approach. And the International Seabed Authority is not necessarily talking to the International Cable Protection Committee, I think, is the governing body there, to talk about whether that will interact in terms of, just from a business standpoint, the miners that are at the bottom of the ocean and the cable layers that are at the bottom of the ocean. So here again, we have an example of, we have these two different legal regimes. They seem to be working really well, but now with emerging uses and technology that we have, there may be some challenges ahead. And so enter the new High Seas Treaty, the silver bullet, the solution for all of this. This is, I put the long name up there. The students know that this is the ILB-BBNJ, right? The International Legally Binding Instrument for the conservation and sustainable use of marine biologic diversity of areas beyond national jurisdiction. Thankfully, the United Nations is referring to this as the High Seas Treaty. That is one of my biggest pet peeves about working in international law, is all of the acronyms. So What is the new High Seas Treaty going to do? This has been, since the early 2000s, nation states coming together and saying, the law of the sea is not cutting it, this trouble at sea, all of these disparate organizations and legal agreements that we have, we need a more coordinated approach, we need better guidance, things are falling through the cracks. So what we're going to see with the new High Seas Treaty is an emphasis on talking about marine genetic resources. Think back to the prochlorococcus. If we can replicate the conversion of energy that occurs, we will reduce our need for fossil fuels. Thinking about the genome information that we're getting from different species. We had a guest lecturer talk to us he was calling in from France a couple of days ago, and he mentioned that right now, the one thing that's on the market from bioprospecting is an anti-aging cream that's made out of jellyfish. So we have a long way to go in this area in terms of actually contributing to society in a positive, my view of what would be positive resources coming from marine genetic resources. But that is one area that really hasn't been defined. And because we have the freedom of the seas for the water column, and we have the common heritage of mankind at the bottom of the ocean, a shrimp that's walking around on the bottom of the sea floor, a living organism, is right now subject to freedom of the seas, not common heritage of mankind. So you can scoop that shrimp up, and you can figure out what that genetic information is, and you can patent that. And as of right now, I think Germany, there's a company in Germany that has over 50% of the patents for marine genetic resources. So some would argue that these species and that this information should not be subject to freedom of the seas, and it should actually be subject to common heritage of mankind. Or maybe that freedom of the seas needs to be adjusted, or that we have marine protected areas. Capacity building is another area that the new treaty is going to address. Place-based tools like protected areas, marine protected areas, which I'm super excited about because of the work that I had been doing on that. I think there's a lot of opportunity to do a better job in terms of different sectors communicating with each other with marine protected areas. And then environmental assessments, which again, the students did a whole day, they can do a whole semester on the legal frameworks that we use for environmental protection to think before we act when it comes to activities. And when we do environmental assessments, the need to do cumulative impacts assessment and the challenges with doing that. Now the students did that, and they looked at whether we should consider including a cruise ship terminal in a town of Pleasant Haven, just in a coastal state area. So imagine trying to do these environmental assessments in the global commons. It's going to be very challenging, but we have a lot of information on a lot of different models and lessons learned from what we've done nationally and internationally, what different countries have done. So I think I'm hopeful that this new treaty will provide us with an opportunity to iron out some of the details that are undermining our ability to establish coexistence in a crowded ocean. So the treaty is halfway through its negotiations. There are negotiations in August, and then the final negotiation supposedly will be in 2020 with a new agreement by 2020. I think that's a little optimistic given international negotiations and how long they take. But this is something I told the students earlier this week. It's a really unique time in history to be able to track this treaty and these developments and all of the exploration and information that's coming from the bottom of the ocean. That's all I have. Thank you so much. Questions?
What about plastic?
Oh gosh, we'll go back to that image, the National Geographic image, right? That is a great question. I mean, and so that's the thing in terms of how to frame an issue this big. The advice I got on picking this as my topic title was pick a species and one example to talk about. And the other advice was only talk about something that you have actually done, which I think is fair as well. But this is we have to think of this as a really big problem. It's a whole systems thinking approach that we need to take. Plastic is some of the negative that's going into, the majority of the negative, I would argue, that's going into the ocean, right? So this National Geographic image, really communicates what we know about that is only the tip of the iceberg. There's some images out there that show the oceans taking the trash out, and what they're doing is the ocean currents are taking them out into the gyres where we have these big plastic pollution solution areas in the ocean. So in terms of thinking about how we're going to address the issue of plastic pollution, I think of that from the standpoint of the cumulative impacts analysis under the environmental assessment bullet that is going to be in the new High Seas Treaty. I think part of what we need to communicate in talking about how environmental impact assessment is done is the various different interactions between the stressors on the environment and how they interact with one another. And that's where plastic would come into play. And now we have a lot more studies coming out from the scientists in terms of the actual numbers of plastic that we have. So I think there is room to include it in our environmental assessments through cumulative impacts analysis. And then the other way to address that is we need to stop producing it and we need to stop using it. We need to stem the tide of plastic. Yeah, that's a tough one. Yep, Caitlin. Right. Right. So I mean, I think you were holding a mirror to the conversations I've had with scientists. So Caitlin spent a couple of years at Scripps studying the bottom of the ocean and the creatures down there, right? And I think that is one of the biggest challenges in terms of environmental assessments. When we think about environmental assessments in state waters and in national waters, we have scientists, over 1,000 scientists just signed an agreement saying that they don't think significance should be the measure by which we decide whether a project goes forward or not because of the fact that the environmental assessments aren't even working closer to home. So in terms of how we do that in the global commons when there's so much scientific uncertainty, I think that the best hope that we have is the precautionary principle, and thankfully we have that. That's stronger with international law and really thinking about it that way. And I think it's taking the precautionary principle and including that in a conversation that decision makers actually care about in terms of the information resources. I think if we can frame this in terms of not so much the uncertainty, but talking about the prochlorococcus, talking about these different species that we're finding, the lost city, this area that's in the mid-Atlantic ridge, where they think we may find the answers to the origin of life itself. So if we can include that, like we don't know, but we do know that there are answers there, should we actually act with caution? If there's some way for us to create, which I know is quite ambitious, but to create our environmental assessments in that way, I think it will be really helpful. And I think that's the other thing I'm trying to do is really come from having done environmental assessment work. And you read the law review article. We had, I don't know how many recommendations we had. We had like 25 26 recommendations for how to better do environmental assessments, right? But I'm trying to step back from that and challenge the assumptions of doing this with the existing law that we have, because this is an opportunity with the new High Seas Treaty to not need to use that framework that I've used for the rest of my career, which is how do we get this done with what we actually already have on the books. This is an opportunity to say, how do we get this done based on the information that we do and don't have. And I think that's where we need to go, and I find that really challenging to think about it in that way, instead of saying, okay, significance is the issue, is to say, wait, and Anna and I had been talking about this, well, maybe we need to challenge the assumption that this is the way we actually do environmental assessments, so. Mm-hmm.
So I think it's great to do big projects, and I have a set of questions that might even be a little bit outside your scope, but I'm fascinated by all this, and I was wondering if you could just talk a little bit about the political economy of these contracts. And so, and this is just so I want to just make sure I'm understanding. The International Seabed Authority
Mm-hmm.
has given out 19 contracts, and so when you were talking about the contracting, the reserve claims and the contractor claims, those are those 19.
I think there's 29 exploration contracts right now, but yes, there's different types of contracts, and some are in different phases of exploration.
Okay. And so do so the contracting parties are the Seabed Authority and a member state or a private company?
So that's a great question. They are going through a member state that is party to the convention.
So it's a private company, but
Correct.
the contract is formally between the authority and the member state.
Correct, which is why, so that's one of the things that was really interesting and compelling about Secretary of State Clinton's testimony was she said if we have U.S. companies that want to do this, their options are to either not do it because they're not going to do it through us or shop it out to other countries.
Okay.
Right.
And can you just say a little bit about profit sharing, what can be commercialized, whose IP law this is happening under?
Yes, IP law.
Looks like?
Right.
Who resolves disputes? Is it the tribunal? Who's profiting and how? And
I know. So as I've been doing this, there's this little voice in my head that's like, I need to learn IP law. I'm afraid to go there, right? So in terms of profit sharing, the details of that are a little bit of a black box with the enterprise. And I told the students the enterprise, that's actually what it's called. It's called the enterprise. But essentially the enterprise is going to get all of these resources. Now, I don't know if that actually means like you take your ship to Jamaica with your nodule, effluent that you have, and then they actually, they're manufacturing what they need to there and then shipping it out, or if it's just the money. I do know some colleagues at Stanford have been looking at blockchain as a way to think about the information, protecting the information and protecting the money and the profit sharing that we're doing. I don't know a ton about that, but I think one of the things that's most interesting about the profit sharing conversation and the implementation of that in terms of who gets the money, I think that's very interesting. And I don't know the complete details in terms of how that's worked out at the International Seabed Authority because I don't think there's actually, revenue yet. But I think even more interesting is going to be who has access to information from marine genetic resources. Because I think there's an even more compelling argument that that's something that all of humankind should have access to. And if you talk to the scientists about the challenges that they face in their work, there is more and more this push for data to be open source, generally in the scientific community. And so I think that's going to help push the envelope in terms of, all information to be open. And interestingly, when I was researching Dr. Chisholm's research on Prochlorococcus, I noticed that she is funded by the Department of Energy. And so I started wondering whether the information that she's finding about the conversion of energy is something that the U.S. has and is not sharing and whether it's something that we would sell or if that's something that really all of humankind should have access to, especially if we want to solve these problems. So I know that doesn't completely answer your question, but yeah, that's what this whole, area is about.
Okay, we should wrap up there so folks can get to class. Thank you.
Thank you.